prosecutor, the DA, to hold off on bringing charges. That itself is not unusual. You can have every day, you have federal authorities saying to the state, hold off and the like when you have concurrent jurisdiction. What makes it unusual here is that the federal government then never brought charges, as Andrew said. So that kind of hold off but then don't charge thing is extremely unusual indeed. I'm not sure I've seen it before.
And Neil, just to that point, Cy Vance also said on Sunday on our network that he was surprised that the federal government did not pursue it once the administration changed. So they had plenty of time. You know, I know that there was January 6th and everything else that had happened that was obviously occupying them when they took office on January 20th. But still, he was surprised, and he knows this case better than almost anyone.
Yeah, and Andrew's exactly right. We don't have an explanation for why. If I had to conjecture one, I could imagine that Merrick Garland comes in, sees January 6th and this whopping investigation in which Trump is, certainly implicated at the very least, and thinks, well, that's where I want to direct my resources and not this thing that is now a few years old, in which there was probably some written determination not to prosecute that. Does he want to flip that? That's a very hard thing to flip, but maybe that's what was going on at the time. And then of course the stolen documents comes up on the radar screen for Merrick Garland as well. Now that's not to excuse Garland. I think we've taken way too long on these two federal investigations. And so, hopefully Jack Smith coming in has energized the prosecution investigations and was going to finally lead to some activity one way or the other, because it's not good for anyone to have these things lingering, not good for the potential defendants, not good for the prosecution as evidence gets older and staler and the like.
I do wonder if it'll prove to be a vulnerability, the fact that the feds have not pursued it, the DOJ has not pursued it, but I guess that's a question that will be answered in the coming weeks, months, et cetera. Let me ask you, Dan, about the delay that we're seeing right now. This arraignment was supposed to start at 2:15. Any chance that the Trump team got a copy of the indictment before heading into court and are reviewing it now? Is that a possibility?
I don't think so. Possibly, but it seems the way that the DA has set this up is, it's a very controlled and orderly process that is really by the book, which is the indictment does not get unsealed until the actual arraignment. So I think it's possible. Look, I don't want to sound trite, but sometimes the wheels of justice do spin slowly, and sometimes there are administrative delays. I mean, maybe the processing, the president's processing was a little slower than they expected, but I don't think they're reading the indictment, no, because I think if they were, I think we'd know about that, given what the defense team and the defendant himself
So yes, I'm sorry, I apologize. So the former president of the United States of America, Donald J. Trump, is under arrest for what they call a hush money, money that he allegedly paid to one of the famous porn star, Stormy Daniels. And the way the money was paid, the way the money was attached to the campaign financing and everything, it has some implication that there was some law broken. So we're going to play this, we're going to follow this with all of you, and then we'll talk about Liberia. When it comes to comparing, many of our people compares Liberia with the United States in so many cases. When it comes to following the rule of law, respecting the Constitution, we do not follow the rule of law in our country, especially with the current government. So we want to continue to follow this until Trump can get out. Right now, he's in a courtroom. He's been processed. And right after that, we will start our own analysis about it, and we'll speak about our country when it comes to respecting for the rule of law. It's very, very important. Imagine the great United States of America having a former president under arrest. It is unbelievable. But yes, it's happening here in America. That's why America is the best country in the world. Whatever is possible here is not possible anywhere else. But let's continue to watch, and we will talk about it later.
So I think this has been set up in a way that the DA gets to speak first.
We are now getting information that this is running 15 minutes late, which means about 6 minutes from now is when we're expecting this arraignment to start. Ari Melber, host of The Beat here on MSNBC, is back with us now. And Ari, as we wait for Donald Trump to come through those doors, presumably he still will, and walk down that corridor, and we'll see if he has anything to say. Will he have something to say inside? Will he be asked, how do you plead? And he responds to that.
He should be asked how he'll plead, and he will say not guilty or guilty, and it's been widely conveyed by his lawyers, so it's a public fact. They've asserted he will plead not guilty. We're going to watch this from the outside. Eventually, as we've noted, we'll get the normal sketches you get from a courtroom that doesn't have live cameras. Most states actually tend to allow this. We don't here in New York City, so that's that. But also, I think he's going to walk out a different man. This is the first day of the rest of his life. He is very accustomed, even in New York, this is a city he knows well. It's a city that in many ways he maneuvered for a long time on the edge of the law and on all of his deals. This is a different experience. And I think it's one that, while everyone has their views about Donald Trump, we've come to know him as a nation. This is still a human being. As we say, the defendant has rights, but he also is going to have to take time to process it. He may not do that in the next hour. He may not do that tonight. He may be in public presentation mode. But in the days ahead, I think today will be an experience that weighs on him because, like so many others who've gone through this experience, we've got some legal experts and lawyers here who know it well. It does change people, even successful people, even powerful people, as they see that they're in a different arena. And for him, it is an arena he does not control today.
But I want to actually ask Katie Tur about this, who has really made a study of Donald Trump over the years, because Donald Trump is different. He processes things differently, emotionally and politically. So does this really penetrate? Does the gravity of what is happening penetrate with Donald Trump?
You know, it's a hard question to answer because you never want to put yourself into somebody else's mind. It's really difficult to do that. But by all outward appearances, if it is going to penetrate, what we're going to see is him lash out, as he does when he feels backed into a corner. And we've already seen that. We've seen him lashing out at the DA, lashing out at the DA's wife, lashing out at the judge, lashing out at the special counsel, anybody that is questioning him or trying to hold him accountable, he is going after them. He's even going after, today alone, his former attorney general, Bill Barr, who, in the conversation we were just having, did not pursue the case against him. I guess he hasn't seen him to be satisfactorily cheering him on over the past few years. Again, he didn't investigate what he called election interference, or not election interference, the fraud during 2020. Donald Trump wanted him to investigate and to hold the new election and to do everything in his power to do things over. And Bill Barr said, no, I see no evidence of it. This isn't there. It's not a case. Donald Trump is not right about this. He used more colorful language than that. We've also already seen the campaign send out a blast. And here are a couple of Donald Trump's lawyers. You see Joe Tacopina, you see Boris Epshteyn, Donald Trump's legal advisor in the campaign. He's been around since 2016, longtime friend of Don Jr. That's how he got into the orbit. But the campaign, as I was saying a moment ago, is already blasting off political T-shirts with his quote-unquote mugshot on it. We know that a mugshot has not been taken. They've used a picture of Donald Trump and put it in front of the standard mugshot look and are blasting it out. Here's Donald Trump walking through the hallway. Let's listen to see if he speaks to reporters.
Will you come speak to us, President Trump?
Okay, so that was pretty brief. I thought he was going to come toward the cameras and enter the courtroom doors, but apparently not. There you can see Jason Miller, communications director on the campaign, follow behind him. So he's entering into that courtroom. The indictment will be presented to him, at which point we will see if the indictment gets unsealed immediately and if it's handed to reporters by paper copy or if it's distributed it through email or if there is just a viewing copy, which reporters would then have to take photos of and send out. We are waiting to see how it goes. But with 30 plus counts in this indictment, it could be a very long document, Andrea, and we're just gonna have to wait at least a few minutes to find out what will happen next.
And we are going to find out, and then we're replaying that video, the very brief video of Donald Trump walking out with security, with his attorneys. He is, and of course, Secret Service, going into that courtroom. In the courtroom, reporters are not allowed to have cameras. They're not allowed to have any recording devices. There are a few still photographers in there, at least for the beginning. It'll be Judge Merchan, of course, presiding and reading the charges, and the indictments will be unsealed at some point very, imminently. And then the defense will be able to ask for a brief delay to read it, understandably, to see what the charges are. We know that they're going to plead not guilty and probably move for several other quick motions. But this whole thing could take about 15 minutes. And once it is unsealed, we will have the answers to what is the legal basis for moving this from a misdemeanor to a felony, as has been widely reported. What are in the 30 plus charges? How far beyond the hush money payment, which is not illegal, but the way it is documented, how far does it go? Do they try to make the novel case that this was an illegal campaign contribution, a campaign contribution that was not recognized as such? Chris, Katie?
Yeah, this is so interesting to see this split screen, right? What you were talking about and what Katie was talking about, which is these very serious charges, the legal implications for Donald Trump, while at the same time, not only is he putting out a fake mugshot with a $47 T-shirt with that picture on it, but Dan Scavino tweeted from inside the motorcade. Jason Miller, who we just saw, had previously tweeted some pictures from the motorcade. We saw his son, Eric, yesterday, who was putting out social media from inside the plane. He said something like, the plane from the plane. And he is continuing to try to make what is, by any other account, a negative moment into something positive for him, something we have seen him do time and time and time again. But again, never like this. Let's talk through what exactly is going on in the courtroom right now, Dan. We now know that Donald Trump is inside. His lawyers are inside. What's happening?
So I think the first thing is, I think the indictment is probably being handed out and the defense lawyers are reading it. And the judge will make sure that happens so that once they actually start the arraignment process, and I agree with Andrea, it'll take about 10 or 15 minutes, probably less, that can go forward smoothly. I think that once the defense lawyers have digested, if you would, the indictment, they'll signal their readiness to proceed. And the judge will proceed with the arraignment, in which the basically the court officer or the clerk is going to basically give the defendant an opportunity to either waive the reading of the indictment, which he's entitled to have, or to go ahead and have the indictment read. My guess is that, having seen it, the defense attorneys will waive the reading of the indictment, and then the judge will ask the defendant how he pleads, and defendant, then Trump, will enter a plea, presumably of not guilty. There'll be some discussion about how this is not a bailable offense, that this is not, if it's an e-felony, this is not a crime that warrants bail. So there'll be no discussion about bail, and they'll proceed to a discussion about motions. And they'll ask the defense lawyers, are there any motions that you wish to file? And what kind of motion schedule would you like? Technically, under New York's criminal procedure laws, the defendant has 45 days to file these kinds of pretrial dispositive motions, like a motion to dismiss or a motion for a change of venue or a discovery motion. But I can guarantee you, in a complex white-collar case like this, that schedule will be relaxed. Once the defense says we'd like this amount of time for these motions, the judge will then turn to the prosecutor and say, you have an equal amount of time to respond, and they'll set a motion schedule, and then they will set a date for the defendant and the parties to return. One question that we've talked about repeatedly is, will the judge say anything and provide warnings or issue a gag order? Because this would be the time to do that, meaning will he actually impose an order that restricts the defendant and his lawyers from saying certain things? Or will he, as I believe he will, and I think I heard Neil say something along these lines earlier, provide some warnings and admonitions so that there are some guidelines and guardrails about what is appropriate and what isn't appropriate, so that if the president and his lawyers act out and say inappropriate things and threaten the prosecutor and threaten the prosecutor's wife and say things that are going to poison a potential jury pool, that he then has a legal basis to say, I warned you. I told you not to do this, and you agreed that you would not do it, and now you have done it. And so I am going to impose this kind of sanction. And I agree with somebody who said earlier that there's probably a continuum of punishment that the judge would provide. I think it was the analogy was to you start when you're dealing with your child at sort of a lower level, and if the behavior does not improve, you progress. So I think that you'll hear that today, and then the arraignment will be over.
So maybe,
Daniel, I've got a couple of questions for you. One of them is, when the arraignment's over and they set up the hearings, the pretrial hearings, and then the hearings or the trial itself, when does Donald Trump have to show up? Is it not until the trial begins itself? And then secondly, the judge decided not to allow cameras in the courtroom. I know that's a longstanding New York rule, but the judge does have discretion. Would you have been arguing if you were in there for a camera in the courtroom?
So first of all, I just want to remind our viewers what's going on, this process of arraignment. So that, goes all the way back to the 14th century. It's reflected in the Sixth Amendment. It's a short thing. It's just notice of the charges. So, our viewers shouldn't get excited that we're going to have like a big substantive debate or footage or anything like that. Basically, three things are going to happen right now. One, the charges are going to be read and Trump's going to learn about them, not the evidence against Trump, but just the charges themselves. The evidence is going to take months to unfold. Second, Trump is going to say whether he pleads guilty or not guilty. And third, as Dan says, there are going to be some motions, perhaps something about Trump and his ability to speak and to attack the prosecutors and the like. Now, you asked Katie about cameras in the courtroom, and Donald Trump yesterday filed a motion to prevent cameras from being placed in the courtroom because he said it would create a circus-like atmosphere, which is, in my mind, a kind of interesting thing for him to say, since he's the one who's been creating a lot of the circus. I think he really just wants to be the ringleader. But But as Ari said a moment ago, New York generally doesn't have cameras in the courtroom. And so it's not surprising to me that the judge hasn't allowed that here. And then with respect to when Mr. Trump would be in court, it would be at the criminal trial. He can certainly come for anything earlier than that if he wants, but I suspect that the next time we would see him is at the trial itself. Maybe they'll make some kind of incendiary motion about the judge being biased, and Trump will try and show up to that argument, and will, as he sometimes does, to intimidate or something like that. But I don't think we will necessarily see him before the criminal trial itself. So today is the kicking off of that criminal process. It's called arraignment, but the trial is a long way from now.
And Jay Johnson, I want to bring you in, of course, former Secretary of Homeland Security, former federal prosecutor, though, importantly, in Manhattan. And you know so well these procedures. How extraordinary is this? Obviously unprecedented to have a former president charged in that courtroom. But, just how difficult and challenging is this for the prosecutors and for Judge Merchan, given all of the attacks and the threats?
Andrea, there are many unprecedented aspects to this. In discussion of a potential gag order, for example, if I were the judge, I'd think twice about imposing a gag order right up front when you're dealing with a presidential candidate who will no doubt make this prosecution part of his platform as a presidential candidate. And when you impose a gag order, you have to be prepared to enforce the gag order. And that would be exceedingly difficult against this particular individual. I agree with the comments made earlier that at this stage, the most important thing from the judge might be admonitions about what crosses the line in terms of personal attacks on the judge, the judge's family, the DA, the DA's family, and then in a form of escalation to see where it goes. The other thing I have to say, Andrea, looking at what's going on, observing the motorcade, observing everything around 100 Center Street, it's obvious to me that a lot of advance work went into this effort today with the Secret Service, where they brought the motorcade. It's obvious that they thought a lot about this, and this is a very difficult situation for them.
We are about to get our first pictures from inside the courtroom. Andrea, you mentioned this just a short time ago, that there are photographers who were chosen to be in there. They could not do it during the actual arraignment, but before the arraignment, the still photographers were in there to take photos. They're from the Daily Mail, the New York Post, the Associated Press, Reuters, and Getty. So we are told that very shortly we are going to get those still photos. It'll be our first look inside that courtroom. We have it. Let's take a look. There he is sitting surrounded by his legal team. Let's talk a little bit, if we can, Andrew Weissmann, about his legal team, which includes a new addition just in the last, 24, 48 hours or so.
Sure. So the woman that we're seeing to Donald Trump's right is Susan Necheles. She is a career defense lawyer. She is extremely well respected. She was one of the primary people who argued the Trump Organization trial in October and November of this year. She lost that trial, but you can be very, very good and still lose a case. That was a very hard case for anyone to prevail in. But she is somebody who has a really good reputation, a very good relationship with the district attorney's office. So we're really actually seeing Donald Trump for once actually really getting somebody who's sort of appropriate to the occasion. And the person to Donald Trump's left is Joe Tacopina, who I think everyone familiar with this show has seen repeatedly on air. I'm not sure he's going to actually enter a notice of appearance as being counsel of record, meaning that he will actually be on this case. If he does, there will be a lot of issues that have been raised about whether that raises a conflict, because he appears to have had an attorney-client relationship of some sort with Stormy Daniels, and she may be a witness. So you can't really be a lawyer for the defendant and have been a lawyer for a witness. There are ways to navigate that, but it will be complicated if he actually files a notice of appearance. And then the newest lawyer is to Susan's right, And he represented Paul Manafort, not in the federal cases that I handled as part of the special counsel investigation, but in a subsequent case that this district attorney's office brought against Paul Manafort after Paul Manafort was pardoned. And if you remember, they said, you know what, I think there's state charges that we can bring because it's really not right that he gets pardoned when he's committed these state crimes. And he prevailed on a legal argument, which was that it was barred by the state double jeopardy rules. So you can understand why he might be attractive to Donald Trump as somebody who can prevail in a case dealing with the district attorney's office. One little point that I would make is this is a lawyer who left his law firm and now is solo, just representing Donald Trump. That is a hard position to be in terms of trying to control your client, because he has one client who is the former president. And so how much control he's going to actually exert when you only have one client is, I think, kind of a fraught position. But fortunately, there are other lawyers there like Susan Neckles.
Yeah.
Can I jump in? Just Andrew's such a good lawyer. We got an incredible breakdown of every lawyer at the bench there. I just want to point out to viewers, this is the first time we've ever seen an image of Donald J. Trump as a criminal defendant in his life. This is the face. This is, as we were told by our anchors here, just moments before the cameras were ushered out of the room. So if people are remembering, the judge did not clear cameras for the actual proceeding, the brief arraignment, but they do have, as is a normal course, cameras right before. This is the image Donald Trump does not want you to see. This is the actual real documentation of him in this now filed case, the people of the state of New York versus Donald J. Trump, defendant. That's the face of a criminal defendant. I will say, as we will be repeating throughout our coverage, he's also legally presumed innocent. But if it's not a happy face, if it is a different Donald Trump, and if it is quite different than the fake, false mugshot that people may hear about from family members or friends or see online, that's the fake news. Donald Trump is purveyor of the fake news because there is no mugshot as far as we've been told as of now. And so this image, those police behind him, they are there to keep order. So while this is a former president with his own Secret Service, he is going, as we've mentioned in our coverage, to adjust to a scene like this. The police are there to keep order, including, if necessary, him and his lawyers in order. He is just a human being. He is just a citizen. I draw attention to this because we were getting the great breakdown, and I mean it because we learned about it, and it's true. The gentleman left Cadwalader. Mr. Takapina is a pit bull. We're told Donald Trump likes that. He's obviously argued the case on TV. But flanked by his lawyers, he is a man who needs criminal defense lawyers and who doesn't want you to see this image, which is why he's doing the counter programming, which we've been careful not. We haven't, I believe, shown the fake mugshot because it's not a real thing. It's just, we've mentioned it so people understand there's that propaganda out there. So this is the moment. This, I think, is a moment in history. And it's really striking, Chris, to see him as a defendant there.
It is, and you don't want to read too much into a single picture, but he seems sitting between, flanked by his lawyers, a man very much in an unfamiliar and uncomfortable situation that he has not ever found himself in below, almost pensive. And he accounts for a very long time, not only they skirted the law, people made accusations against him. He often did not find himself ever in a position where he was actually a defendant. But this is, as if I may steal the line here from Neil, a moment of reckoning for Donald Trump, Katie.
You know, what's interesting is that in 2016 and in 2020, when he was running, mostly though in 2016, because he was running against Hillary Clinton, the images at the rallies and on buttons and T-shirts, and some people even dressed up in prison jumpsuits, was of Hillary Clinton behind bars, Hillary Clinton going to jail, lock her up, was what you would hear at the rallies from his supporters and occasionally from Donald Trump himself. Now the campaign is using a fake mugshot of Donald Trump to garner support for him. So it's an interesting turning of the tables to say that you can't vote for Hillary Clinton, but she's a criminal, to vote for me, even though I've been accused of being a criminal, and here's a fake mugshot to help raise some money. I want to ask about the lawyers, and Ari, I'm going to have to recuse you from this question because it does somewhat involve you. Joe Tacopina has been appearing a lot on television, including on Ari's show, Andrew. Is that helpful? I know Donald Trump wants a bulldog, but are his appearances helpful?
Well, it is a way for the former president to influence public opinion and to get their version of the story out, especially because there's such a false equivalence, because the district attorney, yes, they will have the document of the indictment out there and that will get coverage. And yes, you will hear Alvin Bragg once give a press conference. But after that, as Neil and I know, you're sort of silent other than what you say in court. Whereas Joe Tacopina, Susan Neckles, even Donald Trump are going to be very vociferous about their version, and they can keep repeating it. And so, that's something when I was in special counsel Mueller's investigation, it was just everyone sort of talked about that sort of differential of complete lockdown from the prosecution, and the defense does get to speak. They're supposed to stay within court rules, but sometimes they don't, as we've seen. So, I think that Joe Tacopina it does actually serve that function of getting that story out, knowing that they're not going to really be rebutted from somebody who has the inside information and knows all the evidence. And so I do think it has an effect.
Let me just jump in here and say that NBC News is now reporting that inside that courtroom, Donald Trump pleaded not guilty to 34 counts of falsifying records, felony counts of falsifying business records. Andrew, what does that tell you?
So we'd heard reports about the 34. So this is confirmation. The felony counts is really interesting that there are no misdemeanors. Everyone had been talking about whether there would be this filing of false business records that can be charged as a misdemeanor and as a felony. It's very interesting that the choice was made here to only charge felonies. And I do think that we're going to be very interested in seeing how they get there. It does suggest to me real confidence in the case by the district attorney that they are not charging misdemeanors, that they think that their facts and legal theories as to why it is only felonies is appropriate here. It does suggest, I'd say, real confidence on their part. And it's worth noting, this is a district attorney who initially held off charging when he became the district attorney and said that this case was not ready. And it's only a year later that he has now said it's ready to proceed. And the fact that they're all felonies does suggest to me that there probably was something that happened, in whether it's witnesses or documents or both, in that intervening year while Alvin Bragg has been the new district attorney.
Andrew, let me just jump in here, because it's, according to NBC News, it's 34 counts of falsifying records and conspiracy. Now, NBC News is not reporting felony, others apparently are, but right now what we are reporting is 34 counts of falsifying business records and conspiracy.
So that would be very different. So it sounds like this is, we're in an information vacuum. Obviously the conspiracy count is one where I think people, including myself, thought that they might bring that in order to have the David Pecker, Karen McDougal information and the evidence from that be part of a broader conspiracy involving this catch and kill scheme. And so I wouldn't be surprised if they did that, so that what they're focusing on is not solely Stormy Daniels and those payments.
Is the number of counts that we're looking at here any indication of the breadth, the seriousness? Does it tell us anything about this case?
I think that people should not overreact to that. I think that you can have one core set of facts, and it is possible to have sort of many crimes that emanate from that. So if you have a false business filing and that filing is made repeatedly, and you use it in different ways, or you create many different documents, all connected to one scheme. The fact that you are able to charge that 34 times doesn't really change the way I think that a jury might look at it, but certainly not how the judge is going to look at it. They're going to be looking through past those charges to see what is the actual scheme that's being charged. When I used to do securities fraud, mail fraud, wire fraud cases, you could charge thousands of counts because there's so many ways in which mail and wire fraud can happen, and you usually take representative samples. So I don't think the number of charges alone is indicative of the seriousness.
So Chris, Ari and I were talking before the show about basically what are we looking for at this particular moment? What are we going to be looking for? And I think there are three things that we settled on. Ari, correct me if I'm wrong. One is how many are felony, how many are misdemeanor? So looking at that, how serious are things? Number two, the scope. Is it just around Stormy Daniels, or is it also involving Karen McDougal and the National Enquirer and the potential campaign finance stuff that occurs there? And third, what is the theory or theories that the district attorney, the prosecutor, is going to use to convert these misdemeanors to felonies? At least two we've heard about, bandied about, that these were to further tax violations and that they're to further campaign finance violations. And then
One of the things that Adam Reese is reporting, the 34 counts related to hush money payments to two women.
to two women. So it does suggest that it's Karen McDougal and Stormy Daniels as the two. We'll have to see. Well, maybe there's someone else we don't know about. But if it's those two, it wouldn't surprise me then if part of the theory of the felony enhancement that the district attorney is using is a campaign finance violation one, because McDougal payments were wrapped up with campaign finance violations. Now there can be state violations, that campaign finance law, that's a little hard in a federal election, but there's at least a theory. There could be federal campaign finance charges or violations that could be the basis for this aggravator to make this a felony. We'll have to see.
Yeah, I think
Well,
that's
we will see if it's Karen McDougal in just a moment, but it would make sense because we did see David Pecker go and testify in front of the grand jury a couple times. And David Pecker was involved in the catch and kill of Karen McDougal's story, paying her to not say anything about the affair that she says she had with Donald Trump. We're waiting in just a second. We're gonna go to Adam Reese, who is our NBC News producer, who was inside that courtroom. We're gonna share him with NBC News, so it might be a kind of awkward juggle to get there. And if I have to interrupt, forgive me. That's a fair warning. But if we're talking about Karen McDougal, we're talking about Stormy Daniels, we're talking about the days ahead of the 2016 election. Daniel, I want to ask you, how much will the prosecutors make of that moment in time? Earlier, I was talking about the Access Hollywood tape, the way that he was talking about the former Miss Universe pageant. Are they likely to bring the courtroom, the jurors back to what it was like in the days before the election to try and set the stakes for why Donald Trump would want to be paying a woman off not to say anything about an affair that she says she had?
Absolutely. And I think that one of the critical things that we just learned is that there's a conspiracy count. Now, the conspiracy count is important because it doesn't just give the district attorney a legal platform to bring in the catch and kill narrative, but it actually will likely be what's called a speaking indictment. Now, as Andrew and Neil know, indictments really come in two flavors. The traditional indictment really is just a highly legalistic document that tracks what is stated in the law with a very small smattering, if you would, of facts. A speaking indictment, which is often used when there's a conspiracy count, gives the indictment the flavor of you would, of telling a much more robust, full story. And so it's an opportunity to marry narrative and law. And I don't think there's any question that in the prologue to the conspiracy count, there's going to be a reference to the election, to the stakes, and to evidence that indicates that now defendant Donald Trump had an intention to commit these other crimes related to his campaign in 2016.
And I just want to read what Adam Reese and Derek Gregorian has read. literally, Trump pleads not guilty to 34 counts of falsifying business records related to hush money payments. In 2016, former President Donald Trump pleaded not guilty in a Manhattan courtroom, 34 counts of falsifying business conspiracy for his alleged role in the hush money payments to 2 women. As you've been pointing out, most likely that is Karen McDougal toward the end of his 2016 presidential campaign. And the indictment has been unsealed in the brief proceeding before Judge Juan Merchan.
And Andrea, could I jump in for a second?
Yeah, please.
Just to echo what we've been saying, but I want to put a button on it for the viewers. We now, according to Adam Reese, our court reporter, and our fact-checking process, have the information here about 2 women. That is the first time in this case, in this court proceeding, we've ever had that from the government. There's been voluminous reporting and inference. Our colleagues, Katie Tur and others, saying what we knew about witnesses going in, but sometimes witnesses go in and they don't always lead to charges, or they're used for other corroboration, rebuttal, or fact pattern. So I just want to be clear with the viewers. Breaking news here out of the courtroom. We don't have in our hands yet the full unsealed indictment, but we do have new information for the first time out of court that the DA is charging this as a false business records and conspiracy case with regard to payments to more than 1 woman, to 2 women.
Adam Reese is on our line from the courthouse.
Lester, good afternoon. We all started at about 2:32 when the judge came in. Just prior to that, former President Trump entered the courtroom wearing a blue suit, a white shirt, and a red tie. He slowly walked past the reporters seated. He almost sort of ambled his way into the courtroom. He took his seat at the defense table in between his 4 attorneys. He was seated just in between his attorney, Susan Nechols, and Joe Tacopina. Todd Blanche, who was just added yesterday, was sitting at the end. He spoke on behalf of President Trump. Chris Conroy was the prosecutor, the assistant district attorney. He began by saying that there were 34 counts of falsifying business records in the first degree. When he was asked, President Trump firmly said he pleads not guilty. The prosecutors handed over the indictment. They said it was unsealed at 1:30. In describing the indictment, they said that Mr. Trump tried to conceal a conspiracy and undermine the 2016 election, to identify and suppress negative information. This was covert and illegal payments at Mr. Trump's direction, directed to Michael Cohen. And the purpose was to suppress this affair and this negative information. He paid Cohen, and in doing so, he falsified those business records. He falsified it as cash. This was concealing another crime, a more serious crime. The prosecutor went on to say that Mr. Trump has made recent threatening emails and speeches, both directed at New York City, the courts here in New York, the justice system, and the district attorney's office. He said that these are irresponsible social media posts that threaten death and destruction, and even World War III. He said that these public statements to the district attorney, which included a photo of him swinging a baseball bat towards the district attorney's head, with concerning. They're concerned about this and what effect it will have on potential jurors and witnesses. But they said that this will not dissuade the office, and they're seeking a protective order regarding discovery materials. They're very concerned that some of the attorneys or some of this may be leaked, or that President Trump himself would use some of that discovery in a way that would compromise the potential trial. They began discussing conditions of release. They talked about how defense attorney Joe Tacopina had communications with Stormy Daniels, and that could present a conflict. In response, Todd Blanche, representing Mr. Trump, said that the people just spoke for 10 minutes. They haven't seen discovery. They talk about Michael Cohen, and Michael Cohen has been standing on the steps of this courthouse revealing all kinds of materials that will be relevant in the trial. Mr. Trump has Sorry, I'm just being moved here. They say that Mr. Trump has responded forcefully and clearly. He's very upset, he's frustrated, and he believes that this is an injustice. The hearing is going on right now. The judge said that he's taking the rhetoric and the language he's using, and he's very concerned about it. Lance then said, well, this is free speech. He talked about the investigator, Mark Pomerantz, who wrote specifics. I'm going to have to toss it back to you, Lester.
All right, Adam, so just to be clear, I'm sorry, lost you in my ear for a second. Just to be clear, these charges would be felonies then because he's citing the campaign violation, perhaps, finance violation.
I believe they're misdemeanors, 34 counts of falsifying in the first degree. I would defer to Laura.
Yeah, actually, let me.
If it's falsifying in the first degree, that's a felony.
Right. The first degree falsifying business records is a felony. So that means that we can divine that.
So we just got an awful lot of information from Adam Reese, who was inside that courtroom. And we are just hearing that these 34 counts, including falsifying business records, are felonies. We got a lot of other information that we heard from Adam Reese via the district attorney that he tried to undermine the 2016 election, that he tried to suppress the affair. And in paying Michael Cohen, he falsified business records. But also interesting that he talked about the threatening speeches and social media, which he called irresponsible, death and destruction, and World War III. What is your takeaway, Ari Melber, from what we just heard from Adam Reese from inside that courtroom?
Thanks to our colleague Adam, who, as people could tell, was sort of phoned in, I think, from wherever position he could quickly get to, and he gave us a lot. All of our lawyers here will go through this. I think what's striking is this is not the narrowest possible fact pattern. Again, we need to see the full unsealed indictment, but to answer your question in breaking news, based on what we heard from our colleague Adam, I would call it medium, not small or large. It broadens beyond Ms. Daniels. It includes campaign conspiracy. Again, according to Mr. Reese, it includes the business records, the theory of the case, that this was falsified, it was mistreated as cash, that was a knowing lie. Interestingly, Mr. Cohen made tapes where Donald Trump makes a reference to cash. So they may feel that they have some extra contemporaneous material even beyond the checks. The idea that this was to suppress and covertly impact an election raises the question of what election, what charge. I'm not going to speculate on that statute yet, but I think within an hour or two we'll have it. And I have fine lawyers beside us who may also do that. And lastly, before we hand it off to the rest of our panel, I'll mention that the discussion in court of the threats to the DA was striking. It was a question raised on our air earlier today. It's a question many have raised. Anyone else doing this thug activity, I use that word quite specifically, and thuggishly bringing in the DA's wife and thuggishly posting a picture with a weapon above and beyond everything else Donald Trump has said and his promises of pardons for violent insurrectionists and everything else in the recent history, you would expect there to have been that raised immediately. I think it is striking and notable that it was. I'd love to look at that full transcript. Again, we want to get more information, but those are some highlights.
Andrea, I want to throw to you, but I think it's important to mention that at some point we are expecting to hear from Alvin Bragg, so he will be asked questions about his decisions in bringing this indictment. But go ahead, Andrea.
No, I just wanted to elaborate on something that was mentioned by Adam Reese, which is that in that colloquy between the prosecutor, the assistant DA, the judge, and the defense, there was also the issue of of course, as Ari Melber was just saying, the issue of those threats, the threatening social media posts. And when the defense lawyer said that that was because Mr. Trump was frustrated and was responding forcibly, the judge said he was concerned. And I think it's really interesting that Adam said that he was asking, that the prosecution is asking for a protective order on discovery. Let's listen to more from Adam Reese.
And that this was aiding and concealing the concession of another crime. And again, as I said, they went on to say they were very concerned. He wasn't afraid to bring up the threatening email posts and statements that President Trump has been making, both against the city, the courts, the justice system, including the DA's office. They're very concerned, not only for their own safety, but for the influence of a potential witness or a juror. These social media posts that threaten death and destruction and World War III, the public statements he's been making, the picture of him swinging a baseball bat towards DA Bragg's head. They're very concerned about these posts and, again, the potential effect on jurors and witnesses. But he said this won't dissuade the office. They're seeking the protective order. We'll have to see what the judge decides on that, as well as conditions of release. They want him to be warned about his statements. And as I mentioned earlier, they're concerned that Tacopina, his attorney, Joe Tacopina, had communications with Stormy Daniels, and what he will likely not be able to cross-examine her if, in fact, she becomes a witness. That's certainly a conflict of interest.
Adam, it's Hallie. I'm wondering if you can clarify or explain if the judge had any response to what you're talking about here, the idea that some of these threats have been brought up, not just against the prosecutor's office, but against the judge himself. And I also want to check on one point. I think I heard you say Todd Blanche spoke for Donald Trump, so Donald Trump himself did not say the words "not guilty." Is that correct?
No, Donald Trump did say not guilty very firmly, but Todd Blanche was the attorney speaking on behalf of the defense. In terms of your question about the judge, he said we're taking this rhetoric and language that Mr. Trump is using very seriously.
Danny?
Adam Reese. That's Adam Reese, our NBC News producer, who was inside that courtroom, and we were sharing resources with NBC News. So forgive us for that. He did say again that Donald Trump was the one to plead not guilty inside that courtroom. I do want to go back, Andrew Weissman, to this question of what the prosecutors are looking for, some sort of relief, not necessarily a gag order, but that they made a point to mention that Donald Trump has been threatening prosecutors, threatening the judge, posted that photo of him with a baseball bat next to Alvin Bragg's face, worried and concerned about what it will do to a potential jury. And this is a conversation that we've had in the past. If you are somebody that is picked to be on a jury for a trial including Donald Trump, would you feel safe being on that jury? And say, yeah, the government might sequester you, might hide your identity, whatever. But can you feel confident that Donald Trump or his team might not talk about your identity or release details about your identity or do something that might in some way threaten your own life? So how does the judge handle that, given the history of this particular defendant?
So, Katie, let's just take a step back for a moment and just understand the nature of the question, which is you're asking about threats to a jury if you were trying the former president of the United States because you're concerned about the conduct by the former president or his allies. I mean, it is a breathtaking conversation to have when you sort of step back for a moment. This issue that you've raised is one that Judge Lewis Kaplan, who is the presiding federal judge over the E. Jean Carroll case that's going to happen in less than a month in New York, has had to deal with when he said that he is going to take steps to protect that jury. And that's in a civil case. But the same thing is going to happen in this criminal case and any future criminal cases. These are steps that are routinely taken in organized crime cases where you have those types of defendants. So the courts are capable and able to protect jurors, and jurors rise to the occasion in those very difficult circumstances. But it is a breathtaking concept that this is something that you have to worry about. I should say that now that we're hearing about these being felony accounts, that does suggest, as I mentioned, an enormous sort of faith in the part of the district attorney. And the other is we're getting some information that the theory of the case for why these are felonies goes beyond campaign finance and includes tax charges. And I think the relevance of that is that it leads to it being on a stronger footing. There's a lot of people who have issues about whether a federal crime can be the so-called bump up to get something from a misdemeanor to a felony. And there's concern about if it's campaign finance at the state level, whether that's a preempted crime, meaning that it's not really allowed because it's really about a federal election. But if there are tax charges, that seems that state tax charges, that seems like the DA is trying to really make sure that they have a number of different grounds so that if there's a motion to dismiss, there's really no way that all of this is the case may get narrowed, but it's not going to all go away.
And if I could just pick up on that. So, and I'm going to do something I don't normally do. I'm going to tentatively disagree with my friend Ari. Ari, you had said on the basis on the option small, medium, or large set of charges here. I think that this is large based on everything we're hearing about. It viewed against the range of things we've been hearing about for the last 2 weeks. So if everything here is a felony, there's nothing charged as a misdemeanor. If it's not just about Stormy Daniels, but also about another woman, presumably Karen McDougal, and if the enhancement theory is not just campaign finance violation, but tax, that's pretty much the, going to 11 set of options that the district attorney had available to him. I'm not aware of much else in the discussion up to this point of a charge or a theory that Bragg could have brought that we're not hearing is actually in this.
So what is your question for Alvin Bragg if you were at that press conference, which you think he's going to have?
Right. Well, he would never answer it, but I want to know, what changed? This was something that you had put the brakes on earlier. Everyone thought this thing was dead except for one guy who happens to be sitting with us right here, Andrew Weissman, who wrote a piece last June saying, actually, this thing isn't dead. There may be reasons why it's on a pause, but that it could actually come back. He was the one person who actually thought this was still going on. Bragg obviously, did think something was going on. Something changed. And that's what I want to know. There's two ways of reading that. One is, well, it's, him being political. That's the Trump story, that he basically killed this investigation and then to make his name or something like that, revived it. The other is, no, he was doing his job as a cautious prosecutor. He had these memos from Mark Pomerantz and others, which weren't credible, but for future prosecutors, or new prosecutors came online, including someone from the U.S. Justice Department, Matthew Colangelo, and they looked at it and said, hey, actually, there is something very serious here, and there's a viable legal theory to get us there.
Yeah, and I welcome Neil's thoughts because we're going to do this throughout the day and get a hold of the indictment. So I was at an initial medium. He's at an initial large. Andrew Weissman always goes supersize. If you're familiar with his career as a prosecutor, ask Enron or the Mafia or any number of defendants. But I did want to say, what we're going to watch for is how many tentacles are there. And to Neil's point in the question of whether tax and other conspiracies come in, that may be more difficult for Trump and his lawyers to deal with.
Andrea?
And Joyce Vance, let's talk about your take, small, medium, or large. It seems to me that if you've got tax cases involved here, conspiracy and tax, and fraudulent business filings, you're going pretty large.
I think it is going big, and to the point that was being made before people knew what was in the indictment, there were a lot of complaints, many of them motivated by politics, saying that this was that it was just about some records keeping violations. I'm sure this becomes more clear when we see the unsealed indictment, but knowing that there is a significant number of felony charges, that it's more expansive than Stormy Daniels, that begins to give us a picture of the work that was done here. I have the same question that Neil has. I'm very interested in knowing what changes, but having been a prosecutor for 25 years, having been involved in many extensive grand jury investigations, I can tell you that sometimes when witnesses get in front of the grand jury and begin answering questions, new facts, unexpected facts can come to light, or you can begin to see existing facts through a different filter. And you begin to appreciate that when defendants begin to engage in conduct together, there are multiple crimes.
the conduct that they're engaging in can amount to more than just one crime. And so from what we're hearing early on about this indictment, it sounds like something that will withstand scrutiny.
I wonder if I could just jump in on Joyce's point. This is Andrew. I think one of the things that our newest anchor, Jen Psaki, her interview on Sunday of the prior DA, the DA who stepped down and ended his term in December of 2021, just before Alvin Bragg took over in January of 2022. Her interview gave some evidence as to help understand Joyce's excellent point, which is in her interview, she was asking about that, and Cyrus Vance confirmed that when he left office, that the cases that he was doing, they were investigating, the financial case into Donald Trump, this hush money case, were not ready, that they were still investigating. So you really get the sense that when DA Bragg took over and said, you know what, we still need investigation, that this sort of year-plus period is one where they continued digging, as a good prosecutor would, to make sure you've looked at all witnesses and all possible documents.
And a quick question to Adam Reese, who's now on the phone with us, our NBC producer. Was there an outcome to the request for a protective order to the judge?
There was not while I was there, but I can brief you on what was said from both sides inside the courtroom, if you like. When I left, there was no decision on the request by the prosecutors.
Yeah, go ahead, Adam. Tell us what happened.
Chris Conroy, acting as prosecutor, talked about the 34 counts, said this was in order to conceal a conspiracy and undermine the 2016 election. He said this was an effort to identify and suppress negative information. These were covert and illegal payments made at the direction and to the benefit of Donald J. Trump. The purpose was to suppress the affair, the alleged affair with Stormy Daniels. He paid Cohen by using false business records, falsified cash, and this concealed the concession of another crime. The prosecutor, Chris Conroy, went on. He talked about their concern about threats, these threats that President Trump has made to the city of New York, to the courts here in New York, to the justice system, and even to the DA's office. They're very concerned about the irresponsible social media posts, that he threatened death and destruction and even used the term World War III. These threats were directed, the public statements were directed at the district attorney here. He mentioned the photograph of former President Trump using a baseball bat towards the district attorney. They're very concerned. They would like some kind of order given by the judge to force President Trump to stop these. They're concerned about the effect this could have on potential jurors or witnesses. But he did say this won't dissuade his office. They're seeking that protective order. And that also includes discovery materials. They want conditions of his release. They want the judge to make warnings. They talked about defense attorney Joe Tacopina and his communications years ago with Stormy Daniels and how that could pose a conflict of interest as we move towards a potential trial. He won't be allowed to cross-examine her. Whether or not he can stay on the defense team, that's another question. And then at that time, his defense attorney, Todd Blanche, stood up and spoke. He said, the people just spoke for 10 minutes. We haven't even seen discovery. He talked about Michael Cohen standing on the steps of the courthouse. Every time he comes and meets with prosecutors, he announces all the charges. He said that, you know, Donald Trump has responded forcefully. Yes, he has, but he's upset. He's frustrated. He believes that this is an injustice. The judge responded by saying that we're taking this rhetoric and the language that former President Trump is using very seriously. And Blanche responded, well, there is free speech. The investigator who worked on the first case, this is called the so-called zombie case, Mark Pomerantz wrote a book and he speaks publicly. Cohen has continued to be on every news show. And Mr. Trump is running for election. And We just received a copy of the indictment minutes ago, and he said this is really an injustice.
Adam, it's Katie Tur. Thank you so much for all of that color inside the courtroom. I really do feel like you brought me in there. In terms of the indictment, I know the defense says it has it. Any word on how the press is going to get the indictment? It was unsealed at 1:30. Are they going to hand it out? Are they emailing it? Is there a viewing copy that will be photographed? What do you know?
I don't know, Katie. It's not clear right now. I do know that as soon as this hearing is over, which should be moments away, there will be an email from the district attorney's office detailing the charges. It won't have the thoroughness of an indictment. We'll just have to see how they plan on doing that. There is a question of whether or not it was being kept sealed or not, and we just don't have an answer for that. But we can expect to hear, to see more details of the charges once that press release from the district attorney comes out immediately following this hearing. And then right after that, expected around 3:30. It's almost 3:30 now, so that'll be pushed back. DA Bragg is going to have a press conference here.
And do you know if he'll be taking questions from reporters?
We don't know that. We were just discussing that before the hearing started. He gave a statement after the guilty verdict in the Trump payroll corp trial. He just gave a statement. He didn't take any questions, but we feel in this situation, he's almost obliged to take questions.
Donald Trump went into that room. You see the picture on the right of him between his lawyers at 2:28 p.m. So we're coming up 55 minutes since he went in there. We thought this was going to be fairly brief. We are waiting on the left of your screen to see him coming out. Andrew Weissman, I'm going to ask you, but first let me ask Adam Reese. Do we know what's going on still inside that courtroom?
I can explain part of the delay. Just before we got into President Trump's specific case and indictment, a media attorney stood up and spoke for about 10 minutes and talked about the monumental significance to the public that this case has. And his concern about some of the orders that came out from Judge Merchan yesterday. He understands that there are competing interests, that former President Trump has a right to a thorough defense. But he says we should work on a media plan going forward to avoid chaos. The indictment should be made public. He asked that all media, anything, all discovery be made public promptly. And he also said he wants to make sure people can see President Trump's facial expressions going forward. So we asked, could we put some reporters in the jury box? That's not uncommon. Oftentimes, if there's extra room, they will allow reporters to sit in the jury box. This would allow them to see President Trump's facial expressions. Talked about laptops. Judge Merchan, in his order last night, said you can bring phones, laptops, types of electronics into the courtroom, but you can't use them. That wasn't typical for this judge, but the judge said this is an unusual, this is a novel case. There's high security here and so forth. Today, we're going to keep it like that, but he did seem to indicate going forward.
I'm going to interrupt you. We just
trial.
briefly saw Donald Trump leaving the courtroom. So 3:25, almost a full hour, about 57 minutes inside that courtroom. Donald Trump, who stood up and, according to you, Adam, said very clearly, very firmly, I believe was your phrase, not guilty, but also.
He said it.
Go ahead.
He said it's seated. He said it's seated. He didn't stand up.
Okay, so he was asked how he pleads, and seated, he said firmly, not guilty. Adam, thank you so much. Andrew, sorry, Adam, thank you. Andrew, too many A's here.
Yeah.
And I also want to ask you, Ari, this is all A's. Now I'm very confused. No. You obviously were reacting, both of you, when you were hearing what Adam had to say. What's your thoughts?
Well, to flag a couple things, here we are now. We like to follow the facts and the evidence as we get it. 57 minutes is a very, very lengthy booking hearing. We're watching some of the process here. We'll keep our cameras as we look at the outside of the exterior of that court area.
Looks like Boris Epstein.
Yeah, it looks like we could see some of Donald Trump's lawyers as they make their way out. We already got eyes on the former president leaving. We're watching what looks like the phalanx of people making their way out. Yep, Mr. Epstein, who's one of Donald Trump's lawyers and also was a campaign representative, is there. This was a very long hearing. I think Andrew Weissman could speak to this as well because we were commenting on it as we kind of watched and observed. So the point there is, the point here is I've briefly done a few arraignments and bookings in that very room. I will tell folks, and there we see the former president walking out after his booking, arraignment, and arrest. Our shot is slightly obscured, but we just, yep, you can see there Donald Trump walking out here at about 3:27 p.m. New York time, completing his arraignment after pleading not guilty in his own voice in this case. We're still waiting on getting the full indictment. So
yeah, and saving whatever he may have to say for tonight when he has that speech at Mar-a-Lago.
So to pick up on what we know now that we didn't know an hour ago, just for context again, and our lawyers have mentioned this, you'll see usually in that room, and I've been in it, bookings where a whole line of people will go through. I mean, it looks like a very fast process. You'll see people go through sometimes 3, 6, 9, 10 minutes. This was an hour on one individual, and that may be okay because there were some extra issues. This is an individual who, according to the proceeding today, was called out for inappropriate and perhaps potentially unlawful conduct towards the justice system, the DA, and the judge. So I want to get Andrew in on all of that, but I would just say what we know now, this was a much, and we're seeing them depart, this was a longer proceeding. It had more issues, and it definitely started with a bang, by which I mean, we'll get into the indictment, but the very fact, Chris, that they were raising the defendant's conduct and potential limitations that might need to be placed on him, and he's the former president of the United States, that's extraordinary. That is an extraordinary aspect of this, even above and beyond the unprecedented nature of the booking, the arraignment of a former president. And so, Andrew, you and I were sort of sidebarring about this. I'd love for you to share with news viewers here what you're thinking.
I really think you're right that this is an unusual aspect of this, leaving aside that we have the former president of the United States for the first time ever, not just under arrest, having gone through an arraignment. The arraignment time period is striking, and so I'm going to be very curious about what happened during what is essentially those 57 minutes. And I'm curious to see what did the judge do with respect to the protective order or potential gag order? Did he sort of lay out sort of just some guidelines? But when he said he took this seriously, did he go further than that? Because that, you could imagine, took some time. There also could just be security issues. But you could imagine the judge wanting to impress on the defense team the kinds of things that the judge saw, not just only for himself, but really looking at the DA's office. I do think that the fact that the DA raised it, by all accounts, what I'm seeing is the DA being completely fearless in terms of handling this case the way he would anyone else who did this. You saw a connection with the 2 letters that the DA sent to the House, where Jim Jordan and others had wanted to interfere in this investigation, and they wrote 2 very strong letters saying essentially back off, but put into very strong but much more legal terms. If these are 34 felonies, that also is the DA being fearless and then raising in court what they would raise with any other defendant who was writing about the DA's wife, and we're getting reports child, and about the judge or the judge's child. That kind of threat is the kind of thing that you'd expect the DA raise. It suggests a real fearlessness on the part of the Manhattan District Attorney's Office.
When Donald Trump mentions somebody's name in a negative way, that person, that is usually followed or can often be followed by vitriol from Donald Trump's supporters, some of that vitriol bordering on or venturing into threats of physical harm. What you're watching right now is Donald Trump's motorcade going back up the FDR north. We'll see if he's going to make a pit stop at Trump Tower or if he will take that north to what was formerly known as the Triborough Bridge and straight over to LaGuardia and his plane, and then back down to Mar-a-Lago. Likely that is the case. He is scheduled to speak to his supporters, the country, you could say, at 8:15 Eastern tonight. It's what they're calling a primetime address. Unclear how it will be broadcast, though, since he is no longer the president of the United States. Alvin Bragg will be holding his own news conference, the DA in Manhattan, at 3:45, which is just about 14 minutes from now. Well, he'll be laying out all of the charges and the indictment, where we have yet to see the unsealed indictment and all of the evidence that the DA has collected. We're going to go to Garrett Haake in just a moment. He's in an elevator trying to get out of the courtroom, but he's going to be on the phone with us in just a second to tell us how that hearing ended. Again, it was 55 minutes, much longer than anyone expected it to be. Jonathan Deanstar, our partner at WNBC, is reporting that it did not end with a gag order. Obviously, the prosecution was looking for some sort of relief. We will likely hear from Garrett how firm the judge was with Donald Trump about what he can and cannot say, and whether there was a formal warning for him to stay within the bounds and not to threaten prosecutors or the district attorney. Say what you want, go out and campaign, say that you're innocent, but don't threaten any of the people involved in this case. And it likely did not help Donald Trump or his team that there was an image that they tweeted out of Donald Trump in a baseball bat next to Alvin Bragg's face. Remember, Bragg has gotten multiple death threats, according to the sources in New York, including one in particular that we reported on the air last week, saying, "Alvin Bragg, I'm going to kill you," a letter mailed to the DA's office. Garrett Haake now joins us. He has made it out of the elevator, out of the courtroom. Garrett, what happened?
Well, Katie, about 58 minutes, Donald Trump was in the courtroom. We heard him in his own voice plead not guilty and answer yes or no to several questions from the judge about his various rights, including rights related to his counsel, Joe Tacopina, who the prosecutor suggested may have a conflict in this case because he had previously spoken to attorneys for Stormy Daniels. Now, on the matter you were just describing, prosecutors did present the defense team and the court with copies of specific posts that Mr. Trump had made on his Truth Social network, suggesting that that kind of rhetoric and escalating comments could lead them in the future to ask for more restrictions. And in fact, they did ask for a protective order regarding discovery. Now, the details of that are still going to be worked out, but the gist of it here is that Mr. Trump and his attorneys would not be allowed to comment publicly for any purpose other than his defense on elements of discovery that were handed over to them by the prosecution. The judge made it very clear that there was not an ask for a gag order, nor would he provide a gag order if one were requested. We talk about, based on what we know now, that would be an overly restrictive measure, not appropriate, especially given the unique First Amendment concerns around a candidate for president. He did say, however, that if other posts like the ones presented to him in court today were presented to him again in the future, he'd have to look at it more seriously. So very much an issue. He instructed, after a moment for the defense attorneys to argue essentially that witnesses for the prosecution, namely Michael Cohen, have been speaking so publicly about this case for so long and defending Donald Trump as having been frustrated by this process. The judge very calmly kind of admonished the defense and said that frustration is not an excuse for rhetoric that escalates beyond a certain point, and instructed both parties, both the Trump defense team and the former president and the prosecutors, to caution their witnesses, caution the defendant against escalating rhetoric any further. So that's where we are right now. Certainly nothing like a gag order. Discussions ongoing about what the restrictions would be around that discovery. The prosecution team had requested that Mr. Trump could only review evidence turned over in discovery in his own attorney's office. He wouldn't be able to take it with him. He wouldn't be able to make copies. He wouldn't be able to tweet it or post it or hand it over to the media. The defense team says that's still something they are trying to work through, and that would be impractical. They want to do it at Mar-a-Lago. Discussion ongoing. But that's where we landed on the evidence question.
We have gotten the indictment, and we're printing it right now. It'll be distributed to all of our teams, and we're going to go through it all together. Garrett, can you tell us, it's 16 pages, can you tell us a little bit about what Donald Trump was like, his demeanor in that courtroom?
Very focused. He walked very slowly and deliberately down the center hallway in the courtroom when he came in. And I have to just back up and say, the security in this courtroom was unlike anything I had ever seen. Now, we knew it would be restrictive, but basically the 2 seats closest to the aisle on either side were blocked off and reserved, and no one could sit at them. And at the end of every aisle, mostly the courtroom full of reporters, was an armed court police officer facing us to make sure that all the reporters remained seated. Once Mr. Trump was down that center aisle, making eye contact with some folks along the way, 2 more officers stood directly behind him, making it almost impossible to see him for the duration of the hearing. But we did see him watching his lawyers quite closely, sometimes with arms crossed, sometimes with hands folded directly in front of him, sort of somberly watching the proceedings. Again, on his way out, trying to kind of keep his eyes straight in front of him, but occasionally looking around, making eye contact with some of the reporters on either side. Forgive me for being a little out of breath. I had to run around the back side of the courthouse to get back over here. Interestingly enough, Mr. Trump was represented by the 3 lawyers we've been discussing for some time now as part of his defense team. Boris Epshteyn was also there with him, although he didn't speak, didn't introduce himself on behalf of the court. No Trump family members, no Trump aides, no one else sort of visibly in the former president's side of the courtroom there, just he and his attorney, who entered later than expected. That's 10 minutes after the 2:15 time that we thought we'd first see them. And then the proceedings immediately began. I mean, all of the unique security concerns were very much a part of it. And in fact, became a bit of an issue towards the end of the hearing where you had one of the lawyers for Mr. Trump, forgive me here, I'm coming back around here, Todd Blanche, arguing that the next hearing, which is likely scheduled for December 4th, mark your calendar, Mr. Blanche argued that, given the extraordinary measures necessary to get Donald Trump here to make this happen, perhaps his presence wouldn't be necessary. No, said Judge Merchan. I like my defendants in court, basically. He said, unless, there's something totally unexpected, his expectation would be Donald Trump should be there the next in-person hearing, which would be on motion on December 4th. They also discussed the possibility of a trial date in January of 2024. I don't have to tell anyone on this panel or watching this program, that's when the presidential primary calendar is expected to get started next year. The collision between Trump's legal challenges, the Trump campaign, in stark relief in that courtroom today.
Thank you so much for that, Garrett Haake, who just came out of the courtroom and gave us more information. But again, we have just received a hard copy of this indictment against Donald Trump. It reads at the top, from the Supreme Court of the State of New York, County of New York, the people of the state of New York against Donald J. Trump, defendant, just to see that in writing. One of the things that we see as we go through the counts that every one of them seems to mention defraud and conceal. Ari, I couldn't help but notice how quickly you were going through these pages. What jumps out to you?
Yeah, in fact, if we can get it, Andrew and I have been going through this, so we have it. Can we show this for a second, and then we could go back to whatever else on camera, but I'd love to just show everyone what we've been waiting for. This is the indictment, so we now have it. Everything we've been talking about has been reporting on the court process. Andrew and I were discussing the length of that and the hints from that. We now have the actual indictment, and it does paint a broader picture of Donald Trump's attempts, according to the DA, these are the charges that are not proven yet, to basically defraud and lie in a business legal sense about what he was up to. I'm reading here from the statement from the district attorney, for example. Here's something that's interesting. It talks about a $30,000 payment to a former Trump Tower doorman who claimed to have a story about, quote, a child Donald Trump had out of wedlock, end quote. Allegation. But this is regarding the underlying incidents that relate to the false business record. So under the law, the issue is, according to the state of New York, the people of New York here, represented by the DA, whether that constitutes a crime. In this case, a falsifying record. But I would say that is a different type of incident and allegation than, for example, Ms. Daniels. Again, this is in one instance, again, the allegation, a company that's a separate corporation, not the Trump Organization, American Media Inc., paid, quote, $30,000 to a former Trump Tower doorman who claimed to have a story about a child Trump had out of wedlock, end quote, allegation, not proven.
I need to interrupt you because Trump's lawyers are speaking now outside the courthouse. Sure. Let's take a listen.
Country, you don't expect this to happen to somebody who was the president of the United States. And on the one hand, there's not really any surprises. I know there was a lot of talk over the past several weeks and the past several days about what's going to be in this indictment and what's going to be there that we don't know. There must be something besides what we've been talking about for the past 4 or 5 years. There wasn't. There's nothing. The indictment itself is boilerplate. It doesn't allege any federal crime, any state crime that's been violated. It doesn't allege what the false statement is. And it's really disappointing. It's sad, and we're going to fight it. We're going to fight it hard.
Were you surprised? Were you surprised by anything in the indictment?
No.
How about you, Joe? Were you surprised?
Yeah, I was surprised there were no facts in there. I mean, normally in an indictment you have alleged facts. So they said that this was a false business record entry to aid and abet another crime without saying what the other crime was.
Can you talk about his demeanor? How was he doing?
Trump's reaction was when he saw the charges against him.
When you say what his reaction was, what do you expect his reaction was? I mean, his reaction was exactly what would happen if it happened to anybody that I'm looking at now or anybody that's hearing what you're saying. He's frustrated, he's upset, but I'll tell you what, he's motivated, and it's not going to stop him, and it's not going to slow him down, and it's exactly what he expected. And so to that extent, there's no surprise. But he's also upset and frustrated and disappointed and mad that this happened.
What about the warnings against his rhetoric on Twitter? That was the former president's
What? There was not a warning. What do you mean?
From the judge, talking about
The judge did not
threats that
warn.
had happened.
The district attorney made a statement addressing what they perceived to be, I'm not sure what the words they use, inappropriate rhetoric of some sort. Obviously we responded, and the judge just took it in. The judge didn't warn. He asked the parties to consider what they're saying and not saying.
Guys, he did not admonish the president.
There was no admonishment.
That the president not use language that would incite violence or civil unrest.
He did not request that the president not use language. He requested that everybody involved refrain from using language that's inappropriate. And by the way, that includes the witnesses for the people who are talking just
But it
as much.
also includes the former president swinging a baseball bat at the head of the Manhattan DA.
Well, I don't know where you got that because if
That
you
was a tweet sent out by the former president.
no, it wasn't. And first of all,
social.
that picture was not him swinging a baseball bat. I mean, if you want to distort the facts, go right ahead. I want to address that. Yes, it is. He wasn't swinging a baseball bat at anyone's head. That was a picture of him showing off an American-made bat. Someone else put a picture of the district attorney next to him, and in an article posted that. That's not his article. That's not his photos.
Not using language that incites.
Guys, here's what we're going to talk about today. We're going to talk about the
you committed
insufficiency of this case. And I will say this to you. Today's unsealing of this indictment shows that the rule of law died in this country. Because while everyone is not above the law, no one's below it either. And if this man's name was not Donald J. Trump, there is no scenario we'd all be here today. Please understand that based on these charges.
What are we going to get tonight when he speaks?
When?
Tonight.
8 o'clock.
What are we going to hear?
Well, I don't know. You'll hear it.
You should tune in and you'll
You
hear
think we
it.
know?
Prosecution wanted a trial in January. Did you think that was realistic?
No.
Can you guys talk about, there's a
No,
lot
I
of
don't think that's
speculation about the unity among the defense attorneys.
Look at this.
There's
Look
a
at
lot of-
us.
Is that why you chose
Look.
to do this?
To come out together. We chose
to
come out together so we could speak with one voice. But there is no disunity here. That's gossip and it's nonsense.
And-
We've been working together and we will be working together.
And this, to me, quite frankly, is the best team I've ever worked with, the lawyers. I'm honored to be working with these guys. It's a family, it's a team, and we have one mission, and we'll achieve that mission.
move? What's your next move?
I'm gonna go home and have some food.
What about the change of venue stuff? When do we?
I mean, we're gonna start fighting the case. I didn't mean to be flippant.
When do you start filing motions? I'm assuming one of the first things you're going to
The
do.
judge set a motion schedule.
To dismiss. I assume that'll
The judge set a motion schedule in 4 months. So that's when we'll be filing motions.
This whole notion about how this is sort of like a novel or
It's not a notion. It's actually a fact. It's never been
but
charged
talk
before.
about that. But like,
There's nothing else to say except the district attorney. This office has existed for decades and decades, and you can find one if you'd like. You'll never see a charge like this ever.
You understand
this case?
You understand this? As simple as this. A state prosecutor is prosecuting a federal election law violation that doesn't exist according to federal election law officials. It's as simple as that. You could sum it all up like that.
Will there be anything else in your motion to dismiss?
We haven't even come
What about the
close to
change of
deciding.
venue? There's all this talk. Can someone address that now?
The defendant could potentially post discovery on social media. Will you commit that your client will do that?
That won't happen. And more than us committing, he's committed. We're not here to play
What have you
winning
said
games.
to your client about posting on social media? Have you given him?
We're not having any discussion about what we told her.
What
Were you
about the-
surprised the mention of two women?
Answer this question about the change of venue. There's a lot of
It's premature.
right. So why is he talking about that? Why is he trying to move this to a place
So
like Staten Island?
once again, we're three lawyers here to litigate and fight this case. We're not PR consultants. We're not social media consultants. Donald Trump has made one hell of a brand and became president of the United States with his social media and posts and everything else, his messages. We are here to talk about the case and litigate the case. We can't address what he posts or what he wants to post or did post.
But as his attorneys, have you told him to stop posting this rhetoric,
So
these
what I
messages
said
about the
before was
judge?
we can't, literally, we
Yeah.
can't tell you what we've discussed with
No,
our
I
client.
understand,
So
but are
that's the
you
answer.
concerned that he's continuing to
Not
go
concerned
after
at
the
all.
judge, talking about the judge's wife, talking about the family? I mean,
I don't think the
any
judge
other
was concerned about it.
Yeah, but any other defendant, wouldn't you be like,
Any other defendant wouldn't be
He's
here
not
today.
going after the judge. He is not going after the judge. He commented that he thought that there were some issues that may cause a conflict. That's not going after the judge. He is not threatening the judge. He is not going after the
Right, he's
judge.
going after the
He has
DA.
said that the DA, he is angry because the DA has brought a case that is unjustified. And so I'm not going to comment on it. You may disagree with the way he spoke,
Can
but
you
he
talk
is
about the
angry.
process? Was he fingerprinted? Was there a
I'm not going to
mugshot?
talk about it.
Was there a
In fact,
mugshot?
I think thank you for your attention.
What was his message to the supporters gathered here?
All right, Donald Trump's lawyers are right there trying to say that Donald Trump has not been going after the judge, hasn't been going after or threatening anybody involved, that the baseball bat picture that was tweeted out by Donald Trump was just Trump showing off an American-made baseball bat. Here's one of his last truth posts on the judge. Very unfair venue with some areas that voted 1% Republican. This case should be moved to nearby Staten Island. Would be a very fair and secure location for the trial. Additionally, the highly partisan judge and his family are well-known Trump haters. He was an unfair disaster on a previous Trump-related case, wouldn't recuse, gave horrible jury instructions, impossible to deal with during the witch hunt trial. His daughter worked for Kamala, and now the Biden-Harris campaign kangaroo court. Also, in terms of the evidence that the lawyers say was not presented, I just want to read a little bit from the statement of facts from DA Alvin Bragg, who, by the way, will be holding a press conference in a moment, and we will go there as soon as it begins. But here's from the statement of facts. From August 2015 to December 2017, the defendant orchestrated a scheme with others to influence the 2016 presidential election by identifying and purchasing negative information about him to suppress its publication and benefit the defendant's electoral prospects. In order to execute the unlawful scheme, the participants violated election laws and made and caused false entries in the business records of various entities in New York. The participants also took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of this scheme. They lay out the $130,000 payment to an adult film actress to prevent her from publicizing a sexual encounter with the defendant. They also say that lawyer A, who's identified as Michael Cohen, who is Michael Cohen, through a series of monthly checks was reimbursed by Donald J. Trump Revocable Trust, the defendant's trust, a trust created under the laws of New York, which held the Trump Organization entity assets after the defendant was elected president, and then from the defendant's bank account. There are a number of pages in this. Ari Melber was talking a moment ago about a $30,000 payment to a doorman, which we had not heard before. There's also suppressing a second woman's account, that is Karen McDougal. I'm going to bring in Joyce Vance. Let's talk about this, Joyce. And again, remind our viewers that these payments happened at the end of the campaign when the Access Hollywood tape was out, when he was going after a Miss Universe pageant winner, it came out that he had called her chubby, when he had issues with women, and the campaign was worried that women would not support him. That's the time that these payments were made. What do you make of what the lawyers just tried to argue there in the court of public opinion?
Well, the court of public opinion won't do them a lot of good because ultimately it's a Manhattan jury that will decide on these allegations. And based on what we're seeing now in the indictment and the statement of facts, it's a little bit confusing because there are two documents that have come out of the Manhattan DA's office. One is the indictment. It contains 34 charges of falsifying business records. The statement of fact, though, is a little bit broader, and it explains what you're alluding to, this notion that this was about the election. It was about the campaign, that Donald Trump was faltering as the election drew close because of the Access Hollywood tape, and that, as the statement of facts explains, he embarked upon a scheme. It's conspiracy language, although we don't see a conspiracy count in the indictment itself, saying that he embarked upon this scheme that was designed to keep more of these stories from coming to light. And we know the context, no matter what his lawyers try to argue to the court of public opinion, is that this was all about controlling damage in a campaign environment. In other words, this indictment really is Trump's origin story as a candidate trying to manipulate elections, trying to keep damaging information from coming to light. I think in many ways, the allegation being made by Trump's lawyers that there were no surprises in here, nothing new to look at, is really belied by what we read in this statement of facts, which talks much more broadly than Stormy Daniels. It talks about another woman. It talks about an additional effort to catch and kill stories that could have been damaging to the former president as the election approached. And overall, it is a very compelling case that's made in this statement of facts for why this indictment is important. It is not the sort of indictment that you can shrug off as a political effort to damage a former and future candidate. It is the sort of core allegation that any prosecutor would bring in a situation where you see this evidence of fraud not only being used internally on internal records, but being used with the goal of committing other crimes. Here, lots of tax violations that are apparent. And that one of the most compelling things we see in the indictment is the repetition, time after time. These counts all mirror each other. It's not one accidental incident of conduct. It's not one time the records are incorrect. It is time after time after time, most of these counts being charged on different days.
Daniel Horowitz, as we wait to hear from Alvin Bragg, that could happen at any minute now. We have just learned from our producer on the scene that December 4th is the next in-person hearing date. What happens between now and then? What would you expect is going on inside the Trump legal team and inside the prosecutor's office?
So just in terms of scheduling, I mean, I think we heard that there's got to be worked out the schedule regarding discovery. Clearly, this became an issue and was probably one of the reasons why the arraignment, which is ordinarily 10 or 15 minutes, took so long. There's a lot of discovery, and clearly the prosecutor is very concerned about the disclosure of grand jury testimony, witnesses' statements, and all sorts of information that they're concerned that the president, now defendant Trump, will use inappropriately, particularly because of the threats that he's made publicly about the district attorney's office, the case, as well as the district attorney himself and the district attorney's wife. So what I'm hearing is that there's got to be a schedule worked out among the defendant's legal team and the prosecutors for discovery. And then in 4 months, the defense will have an opportunity to file whatever motions they're going to file, change the venue and try to get to another court, and then ultimately to dismiss the indictment. The prosecution will then have 4 months to reply to those motions, and that takes you pretty much toward the end of the year. You need some time for the judge to make a ruling, and that's the reason why you've got a December 4th date for the next appearance, where defendant Donald Trump will appear and the judge will render a ruling on whatever motions defendant Trump decides to file.
Daniel Horowitz. Daniel, thank you very much for joining us. And what you're seeing on your screen right now is Donald Trump's motorcade. They are now in Queens, New York, headed toward LaGuardia Airport, where Donald Trump will get on his plane, his Trump plane, and head back to Mar-a-Lago. Again, he'll be making an address of his own at 8 o'clock tonight. I think it's notable that he never addressed cameras other than a thumbs up or a wave today, not at Trump Tower, not in the courtroom, not afterwards, never addressed cameras. I know there was discussions within the Trump team about whether he should. And Donald Trump, at one point even talking, according to New York Times reporting, about how he should make a bigger show of it, reveling in the idea of wanting a perp walk. Let's talk about what we're finding a little bit more in this indictment as we await Alvin Bragg. Joyce, I want to talk about the tax issue here. Joe Tacopina and Donald Trump's lawyers are all saying that this is a novel case, that the DA is relying on a state crime over a federal crime to make it a felony. Does the addition of tax charges here still make it novel, or does it strengthen this case in a different way?
Well, it's not nearly as novel as I'd like to make it out to be. This is, as many of the former DAs from this office have told us, this is a bread and butter charge for this office. While it could have been novel had there been certain ways that the charges were presented, this is pretty much driving straight up the mainstream here. To charge it in this way, to include tax charges that are clear violations of New York law. And look, something that prosecutors will do in an indictment where some charges are very clear and others may require litigation down the road because there's not legal clarity, is they will make sure that there's a sufficient grounding so that any convictions that they obtain can be affirmed on appeal. It's very clear in this indictment that there are some bread and butter charges that use crimes to accelerate the misdemeanor into a felony that will withstand scrutiny.
And so in our final minutes here, Katie Tur, let's just recap what we saw today, the extraordinary amount of information that came out. You just talked about in both the indictment and in the statement of facts, but also a Donald Trump who, according to his lawyers, is sad and disappointed and frustrated and upset and mad. And I'm sure he will express some of that tonight when he has his say. As you pointed out, unusually for him, quiet, having nothing to say, either leaving Trump Tower earlier today, going into that courthouse, or leaving that courthouse and going directly to Queens. But the bottom line here is that in a courtroom today, on behalf of the state, they charge Mr. Trump falsified business records as part of an illegal conspiracy to aid his campaign, and Katie, to undermine the election.
And what we just saw a moment ago, we changed the DA's press conference. We're waiting on that. But we're seeing in that image Donald Trump at the defendant's table. Donald Trump as a criminal defendant, a former president for the first time in our history as a criminal defendant indicted. And we should note, this could be the first of other indictments, potentially many other indictments, 2 special counsel investigations, an investigation by the DA in Georgia, all currently pending. What happens with them? We're going to have to wait to find out. Who knows how long? Potentially very soon, though. That's going to wrap up our special coverage of Donald Trump's arraignment. Thank you very much for joining me and Andrea Mitchell and Chris Jansing for these last 4 hours. Deadline White House starts right now.
Hi, everyone. It's 4 o'clock in New York. It's all happening. The gang is all here with you on a history-making afternoon. Just so you're aware, and in case I rudely interrupt any of the brilliant minds we've assembled to talk us through the next 2 hours, in a matter of about 10 to 15 minutes, Manhattan DA Alvin Bragg is expected to address this newly unsealed indictment of the twice impeached, now indicted ex-president Donald J. Trump. It'll be the first time we hear from him since Trump turned himself into law enforcement this afternoon. We will bring Alvin Bragg's remarks to you live as soon as they begin. While we wait, a lot is happening at the moment, including developments in just the last few minutes. We now have hands on the actual indictment, and it's a doozy. It has just been unsealed. People are still going through it, processing it. It has just been made public. You can read along with us if you want to. Importantly, it includes 34 felony counts of falsifying business records in the lead up to the 2016 presidential election. We understand, thanks to our NBC News colleagues there in the courtroom, that it was Trump himself, in his own voice, pleaded not guilty today. The former president is right now on his way to LaGuardia Airport. He's going to take off in his plane, fly to Mar-a-Lago, blah, blah, blah. Prosecutors this afternoon shared with the judge a number of examples, though, of online threats that have been made by Trump in the past few weeks in order to make a case that this type of hostile rhetoric could spoil a jury pool, among other things. Reading this indictment along with us, we have New York Times investigative reporter Suzanne Craig. She's been covering Trump and his finances for years and helping us understand what we should be looking for. She's over there with her pen. I can't wait to hear what she's underlined. Former FBI General Counsel Andrew Weissman is back. He's been with all of you. We've all been listening to him all afternoon. He investigated Trump during his work on the Mueller probe. John Heilman is with us for the 2 hours. He's executive producer of Showtime's The Circus and host of the Hell and High Water podcast from The Recount. Former Florida Congressman David Jolly is also here. Lucky for us, they're all MSNBC contributors. I was going to say unlucky for you, David Jolly. He's heading to Florida, to your home state. But let's focus on what Alvin Bragg has done, what Alvin Bragg has kept secret.